I'm a municipal judge in the state of Utah for the cities of Holiday and Cottonwood Heights.
Good morning. My name is Brit Krelmeyer. I am born and raised in Las Vegas, Nevada. It's so good to be with you guys today. I'm a We the People alum, and I am a practicing attorney in Boise, Idaho. Les, you gotta unmute.
I'll be with you in just a moment.
You're good. We can hear you, Les.
Okay, did you hear my introduction?
No, Les.
Cristina, my picture is gone.
Every picture's gone.
We can see your picture, Les.
We can see you.
I cannot see yours. That's the problem.
Are you on gallery view or speaker view?
I'm not getting any view at the moment. All I have on my screen is the word Zoom.
Okay, if you look down below, Les, there's like probably a little icon, and it's got a little tiny blue camera. Do you see it down below? It's like a blue camera. Click on that, Les. It should open it back up. It'll open like a new window.
I'm in the process. I will be with you in just a moment.
No worries. This is exciting for us too. As you can tell, this is something new for us. So we appreciate you guys being patient with us as we go through this.
I'm just getting a chat button.
Okay, I'm gonna put Les on mute while they're working that out, and then I'm gonna let our Unit 5 get started just because we are on a pretty strict timeline.
Okay, lovely. Unit
Hello,
5.
good morning, everyone. I am Cristina Cervantes, and outside of We the People, I am the JROTC Battalion Commander, and will be attending the University of Nevada, Reno, majoring in public health and minoring in psychology.
Hello, my name is Lucy Donahue, and outside of We the People, I am a Questbridge scholar and will be attending Washington and Lee University to major in history and business.
Hello, good morning. My name is Mary Jane Hatchett, and outside of We the People, I'm a competitive dancer, and next year I'll be attending Southern Methodist University.
Wonderful. Congratulations again on being at the finals. The question for Unit 5 reads as follows. Richard Posner wrote that, quote, "The American public worries more about the invasions of privacy than about summary proceedings against suspected terrorists, curtailments of freedom of the speech of law-abiding, or the right of the media to publish government secrets." Do you agree or disagree with this statement? Why and why not, or why not? To what extent, if any, is privacy in jeopardy today? What protection, if any, do people have from privacy violations by governments or businesses? You may begin. Ooh.
Justice Robert Jackson wrote, "The choice is not between order and liberty. It is between liberty with order and anarchy without either. If the court does not temper its doctrinaire logic with a little practical wisdom, it will convert the Bill of Rights into a suicide pact."
We agree with Posner. The American public does worry more about their individual rights to privacy than the nation's common good.
Domestic terrorism is the largest threat to national security, as the Gun Violence Archive reports that in 2019, there were more mass shootings than days. The threat of homegrown terrorism should supersede the privacy of the individual. As Posner wrote, privacy is the terrorist's best friend, and the terrorist's privacy has been enhanced by these technological developments.
Ultimately, the courts will always be left behind with rulings surrounding technology, merely due to the rapid speed that technology advances. Moore's law states that technology moves exponentially, meaning that advancements double every 2 years, creating more distance between court decisions and progress. This can be seen with the surveillance issues prominent in Carpenter v. California, and Kylo v. United States.
In order to maintain the balance between security and privacy, transparency and education of the individual are vital so that citizens are properly informed before waiving individual rights.
Privacy is in jeopardy today due to the advancement of technology and the public's lack of knowledge regarding privacy rights.
One example is the advancement of facial recognition software that can be used to either infringe on individual liberties or uphold the common good.
China's use of that technology to arrest protesters spawns major concerns with the ongoing Hong Kong protests. At the same time, the US uses facial recognition as a form of security in airports, which raises James Madison's concerns about order, liberty, and the social contract theory to maintain balance.
The solution to this imbalance is the education of individuals regarding their rights on online platforms, which would give citizens the opportunity to learn about data mining technology and the aspects of it that are beyond their control.
As scholar Stephen Aftergood explains, the development of this type of data mining technology has serious implications for the future of personal privacy.
Social media companies profit off their users' data while consumers are completely unaware of how their personal information is bought and sold. To achieve a functional solution, both the private sector and the government must assume responsibility.
According to the third-party doctrine, individuals no longer own their data once agreeing to companies' pseudo-contracts of adhesion, which are far too complex for the public to understand.
This demonstrates why solutions such as the California Consumer Privacy Act and the General Data Protection Regulation in the European Union are needed to properly protect consumers, in addition to possible regulations enacted under the Commerce Clause in Article 1, Section 8.
However, private corporations are not completely at fault, as the government has blocked numerous attempts to create privacy safeguards for citizens online. In Ashcraft v. ACLU, the government struck down the Children's Online Privacy Protection Act, which protected minors from obscene images on the internet.
Although there are protections against privacy violations regarding both businesses and the government, as technology continues to develop, we need to extend both these protections and the education about them. As Mashable CEO Pete Cashmore states, privacy is dead and social media holds the smoking gun. Thank you.
Thank you. You mentioned Article 1, Section 8 in your remarks, which identifies that necessary and proper clause in particular. So do you believe that by virtue of that necessary and proper clause, there's justification in invading the privacy rights such as tracking your cell phone?
As Richard Posner believes, he believes that privacy should somewhat be sacrificed in order to promote the common good in times of national emergency. So yes, I do believe that this is a part of the necessary and proper clause because as we can see with the development of technology today and the third-party doctrine with the idea of us giving away our information with consent, the idea of privacy is almost dead.
Additionally, this relates back to Alexander Hamilton's philosophy on the necessary and proper clause, and that it should be used to advance the country and should be used often rather than just seldomly.
We also see that
I'm so sorry. I'm going to go ahead and ask another question. Because technology is rapidly evolving, you say the courts are slow to adapt the necessary changes. What type of legislation should Congress pass to protect our privacy while still protecting the common good?
Certain regulations, such as the California Consumer Privacy Act, should be introduced throughout all of the states because this allows citizens to know what personal information is being collected. It allows them to opt out of the sale, and it also allows them to potentially gain compensation.
Additionally, even when the federal government has blocked these protections for citizens online, such as in Ashcroft v. ACLU, other states, including Delaware with their code 12004, have passed similar acts in order to protect their citizens, demonstrating the idea that states are the laboratories of democracy, and if they implement these protections, then we can pass this on a federal level.
Les, do you have a question?
The threat of terrorism justify complete abandonment of private rights of the citizens. Can you hear me?
We only
yes,
caught the last half, Les.
Okay, I'll start again. Does a state of war or the threat of external terrorism justify the abandonment of the private rights of citizens?
No, because as we can see during World War II, the U.S. actually got this wrong with Japanese internment following Korematsu v. United States. So if we abandon all rights during a time of national emergency, we can spawn major issues with individual liberties.
Disagreeing with Lucy, with the Foreign Intelligence Surveillance Act as well as the Patriot Act, this includes terrorism. I believe that in a time of national emergency, privacy rights should in fact be somewhat diminished within the citizen due to protecting the common good of the nation.
You contrasted domestic terrorism as well as mentioned the issue of educating individuals about their rights. However, given our current COVID-19 situation, should we not consider that the relinquishment of those rights are necessary for the good of all?
We should not have to publish the names and the identities of individuals infected with COVID-19 because that is a complete invasion of their privacy rights under the HIPAA doctrine.
However, this can somewhat be beneficial for the common good. As we can see, Apple and Google have actually developed a tracking app, which will be developed in late May, which will not release the names of the people. However, it will allow people to know whether or not they have been around someone who has contracted the coronavirus.
Brit?
You mentioned that we have to protect the citizens. But when the citizens go on to these social media websites and give away their information so freely, do they give their consent?
This is why digital online learning literacy is so important. So in fact, Sam Weinberg, a researcher from Stanford, developed a civic online reasoning course for people to learn about their rights and know more about what they're giving away when they consent to giving away these their information on these social media platforms.
In addition, this is why we deemed the consent pseudo contracts of adhesion, because although it is not necessary for individuals to go online, social media has become fundamental in how we communicate. So it is a necessity to some extent, which is why education through acts similar to Nevada SB 322 to educate students in schools about digital literacy would be a good solution.
Les, do you have another question?
You mentioned Carpenter versus US, a decision in 2018. Oh, we're out of time, and I'm sure that was a brilliant question. I'm sure your response would have been equally brilliant, and I will score you accordingly.
Let's give you guys a round of applause.
Well done.
Amidst the glitches that we had, you did remarkably well. Let me say that I am impressed by the depth at which you were able to address the questions as posed. Additionally, how you applied it to current situation and your thoughtfulness in its application. You cited statutory provisions, you cited case law, and as a judge, I'm always interested in case authority. So very well done by all of you. Thank you. Brit?
You guys did a great job. I mean, we've got other teams to see, but I didn't want your presentation to end. I wanted to keep asking you questions. part of why I love volunteering to judge you guys is because it's inspiring. You keep me going. I still have faith for our country because there's going to be exceptional leaders like you all. So keep it up.
I would also congratulate you on your hard work this semester. I appreciate the fact that you're willing to stay in the competition in spite of our current social problems. Thank you for your hard work. Be aware that you are now informed citizens. You've been given the gift of knowledge, and it comes with a duty to become politically active, to vote, and to otherwise attempt to bring these issues to the attention of your fellow citizens. The only comment I would make substantively is that if you go back and read the Carpenter decision, you'll see that it limited the application of the third-party doctrine to cell phone ping, saying, while a person might be aware that his cell phone pings off towers and someone could trace that information, it says it is not a voluntary exposure. And while a user might be abstractly aware that a cell phone provider keeps logs, it happens without an affirmative act on the user's part. Therefore, government cannot access those cell phone pings without a warrant. So the Supreme Court has done what it can to limit the government's access to your private information, saying it must be a voluntary disclosure under the third-party doctrine. But with that little bit of substance, I will tell you again, congratulations on your hard work and your excellent presentation today.
Thank you.
Thank you.
Thank you.
Absolutely.
Guys, make Nevada look good.
I would like to invite all of our guests to feel free to unmute themselves so that we can give these amazing students a round of applause for all of their hard work.
And thank you to the guests for being there to observe.
All right, I'm going to send our awesome judges back to their breakout room, and then we'll organize students. So here we go.
Nice work, crew.
Great
Yeah,
job,
ladies.
guys. Way to go.
Great job.
How do
You
you
guys-
feel? You're done.
Woo.
That's the best part, right?
Yeah.
Exactly. Cristina, you got a little bit elbowed out there, but you're
Yeah, I
great.
was like about to say something, and then she kind of just like, well, I'm asked the next question. I was like, oh.
Sorry about that. It's hard online. Yeah.
Exactly. And it's hard to replicate the national style of judging in this medium, which is
Yeah.
interesting.
Definitely.
But you guys did great. Holy evidence.
Yeah, right? I got pages and dude, I got like 3 pages of notes, you guys.
You got Delaware state law. That's so cool.
Yeah, what? And Nevada state law too? Rocking it, rocking
Yeah.
it.
You did a great job.